Today on BenchBriefs, we're looking at a fresh Supreme Court of Canada decision that dives into the tricky balance between provincial and federal powers. Opsis Airport Services Inc. v. Quebec, a 2025 case that challenges how far provinces can go in regulating airport services without stepping on federal toes. So, what's this all about? Opsis Airport Services is a company that provides ground handling services at airports in Quebec. Think of everything that happens on the tarmac: loading and unloading luggage, moving aircraft, and other essential support operations. Quebec passed a law that imposed licensing and operational rules on companies like Opsis, essentially regulating who can provide these services and how they must operate. Opsis wasn't happy. They argued that this provincial legislation was stepping into federal territory. Why? Because aeronautics and interprovincial transportation, say the regulation of aircraft and the movement of people and goods between provinces, are areas that the Constitution Act of 1867 clearly assigns to the federal government. Opsis said Quebec's law was interfering with federal jurisdiction, making it ultra vires or beyond the province's constitutional authority. The key legal question before the Supreme Court was whether Quebec's regulation of airport ground handling services was constitutionally valid. Was this a legitimate exercise of provincial power, or was it an unconstitutional intrusion into federal jurisdiction? The court had to consider two important doctrines here: federal paramountcy and interjurisdictional immunity. Federal paramountcy means that if there's a conflict between valid federal and provincial laws, the federal law prevails and the provincial law is inoperative to the extent of the conflict. Interjurisdictional immunity, on the other hand, protects the core of a federal power from provincial laws that might impair it, even if there's no direct conflict. In this case, the court examined whether the provincial law impaired the core of the federal power over aeronautics and interprovincial transportation, or whether it simply regulated a local aspect of airport services that falls within provincial jurisdiction, such as property and civil rights or local matters. The Supreme Court ultimately ruled that Quebec's legislation was constitutionally valid. While the federal government has exclusive jurisdiction over aeronautics and interprovincial transportation, the regulation of ground handling services at airports is not part of the core of that federal power. Instead, it relates more closely to local matters and the province's authority to regulate businesses and services within its borders. The court found that the provincial law did not conflict with federal legislation in a way that triggered federal paramountcy, nor did it impair the federal core enough to invoke interjurisdictional immunity. Why does this matter? This decision clarifies the boundaries between provincial and federal powers in a sector that's both national and local. Airports are gateways connecting provinces and countries, but they also operate within local economies and communities. The ruling confirms that provinces can impose certain regulations on businesses operating at airports without automatically infringing on federal jurisdiction. This is significant because it respects the federal structure of Canada, allowing provinces to address local concerns and regulate economic activities while recognizing the federal government's role in overseeing the broader aspects of aeronautics and transportation. For businesses like Opsis, this means that compliance with provincial licensing and operational requirements is part of the regulatory landscape they must navigate. For provinces, it affirms their ability to enact laws that manage local services connected to airports, so long as they don't cross the constitutional line into federal powers. In a broader sense, the case highlights how the Supreme Court continues to balance the sometimes overlapping jurisdictions in Canada's federal system, ensuring that neither level of government overreaches, but that both can fulfill their roles effectively. Thanks for listening to Bench Briefs. Join us next time for another episode where we break down important legal decisions shaping Canada's law and society.